We're up on YouTube, we're up on Zoom, we co-host, we're good to go.
This is docket 25-1960CZ. Olive Branch Assisted Living versus Donald Penner. Counsel?
Good morning, Your Honor. Attorney Tina Gray on behalf of the Olive Branch, and I have Bob Davis here on behalf of the Olive Branch.
Thank you. Good morning.
Morning, Your Honor. Michael B. here, my law partner Gregory Friswell, and with us is Dr. Donald Penner, the defendant counterclaim.
Thank you. All right, and this is, you may all be seated. So we have some counter motions, correct? And the first one is a motion for summary disposition and jurisdictional challenges. Is that correct?
Correct, Your Honor.
All right, you may proceed.
Thank you, Your Honor. So this claim began in district court. This was a very straightforward action for collection. Dr. Penner lived at the Olive Branch, which is a senior assisted living facility. So there's room and board that is owed every month for housing Dr. Penner and paying for not only for his housing, but for his meals, etc. And so Dr. Penner lived at the Olive Branch for several years, but then there came a time when he wanted to stop living at the Olive Branch. And so he moved out with 2 months and 5 days owing. So an action was brought in district court to collect on that amount of unpaid room and board. There was a action for superending control that was filed. So the current counterclaims that had been brought here were filed or attempted to be filed in district court. And the judge in district court said, no, I'm not going to allow these counterclaims because of the same arguments I presented to this court in terms of the inability of the counterclaims being asserted to state a cause of action. And I've set that forth in my motion, and I'll be happy to speak to that, but I'm starting off with the procedure. While there was a motion for reconsideration pending in the district court, Dr. Penner filed the action for superending control, which Your Honor granted, and that closed the district court case and opened the circuit court case. And then Judge Cole got appointed, and then it got reassigned to you. So there was a little bit of a procedural hiccup. When this court granted the motion for superending control, I actually filed a motion for reconsideration on that order granting superending control. And technically that's still out there because when you granted the order for superending control in a different case number, that motion for reconsideration has never been addressed. So I do just raise that.
All right, we'll pull that. That's probably an oversight, but let's, on my law clerk, we'll pull that. Thank you. I apologize about that. Thank you.
I'm just trying to get the full procedural history
Got
of the
it.
case.
Okay.
So then we have the counterclaim here. I would say from a procedural standpoint, the counterclaim was never properly served. I mean, when this court said, yes, you may file a counterclaim, that probably should have been filed on my client, like all claims are, but that was not. So I sort of skipped over that procedural. I was aware of it, so I filed this motion as the first response of pleading. The motion that is before the court today is saying that the 5 counts asserted do not state causes of action as a matter of law. And I'm assuming that the court has read through. I know that I filed this in May of 2025, Your Honor, so that was quite some time ago. And honestly, I was reading over the transcript of the hearing that took place in the district court, and the same arguments were made before the district court for why the district court should not have allowed this counterclaim. These are very specific causes of action that they're claiming, and under Michigan law, there needs to be some specificity that's attached to certain things. For instance, conversion. If you're talking about conversion, you have to talk about specific money. You can't just say money. The same thing with fraud. If you're talking about anything that deals with fraud, the court rules require that you state with specificity what fraud you're trying to assert took place. You can't use the generalized word of fraud. You need to be more specific. You need to talk about what it is that you think constituted that fraud. And of course, with regard to the claim of false imprisonment, I think we've asserted here and we've attached the complaint, the fact that there was a Shiawassee County Probate Court guardian conservatorship in place at the time that we're talking about Dr. Pinner residing at the Olive Branch. So during the time period that Dr. Pinner that's at issue, he resided at the Olive Branch for a number of years, but the only thing at issue is February, March, and 5 days in April of 2024. That is all that's at issue. And during that time period, at issue in terms of non-payment of room and board. And during that time period, there was a guardian and conservatorship through the Shiawassee County Probate Court. So the issue of false imprisonment can't get off the ground when it wasn't Dr. Pinner that was able to decide where he was living. He was a ward, he was being protected, and it was up to the guardian conservator to decide where he would be housed. And so I have attached here the order regarding the appointment of the temporary guardian of an incapacitated person. This was done by the Shiawassee Probate Court, and it clearly states under paragraph 9, the A second says emergency medical needs and placement. So clearly placement, where you're going to be residing, was court ordered by the Shiawassee Probate Court. This court, if you want to challenge what happened in the Shiawassee Probate Court, doing a collateral attack here is not what Michigan law allows. If you want to collaterally attack the Shiawassee Probate Court, that is not appropriate by making a claim for imprisonment. So that's how we address that matter, Your Honor. And let me see if there's one other argument I need to put forth. And I would also assert that this is a motion under 2.116C8, because I'm asserting that there is a failure to state a claim. None of these causes of action in the counterclaim can get off the ground as a matter of law. In order to rebut that, they would have needed to have presented more than just their motion and their brief. They would have needed to come forward with evidence or affidavits or something in addition to what they have filed, which they did file April 28th. And so we have conversion, there's no specific money. The pleadings fail to state anything other than the generic term money. So I have no idea what money they're talking about. And again, the case law is very clear. It would have to be very specific money that you had a duty to preserve for another person, and that none of that is asserted here. We've also talked about the specificity needed for fraud and misrepresentation. I cite Michigan Court Rule 2.112, paren B1, which is the requirement for stating fraud with specificity. And again, we just have generalizations. We have nothing that tells me, even gives me the character of what fraud they think occurred. False imprisonment I've already addressed with regard to the probate court. And then intentional infliction of emotional distress. Again, I'm citing case law here in terms of the elements that need to be presented to this court in order to state a claim for intentional infliction of emotional distress. But more importantly, it needs to be so outrageous, as I've cited here. It needs to be an extreme degree. It needs to go beyond all possible bounds of decency. It needs to be regarded as atrocious and utterly intolerable in a civilized community. And this is
what utterly intolerable and what?
Civilized community. Thank you. And that is citing to the Lucas versus Awad case, 299 Michigan App 345, and that was decided in 2013. But we do not have that kind of utterly intolerable behavior here. Again, this is a very simple case, Your Honor. The Olive Branch is a assisted living facility. It actually does not exist anymore today, but at the time at issue, it was a licensed assisted living facility providing housing, room and board to Dr. Pinner. So I do not think that we have intentional infliction of emotional distress. Because all of these arguments were raised in the district court and these same responses were articulated at a hearing in the district court, it was even stated that during that hearing, the district court judge, if I can back up for a minute, did say, well, if you have those claims, you're free to file an independent cause of action in the circuit court. If you want to file a case in circuit court, you can file a case in circuit court, and maybe the circuit court will decide to combine these two actions. But the district court held that the claim for unpaid room and board was properly before the district court and needed to stay within the district court because the jurisdictional limits. There's a little over 10,000 at stake here for collections, so it does not rise to the $25,000 to bring it into the circuit court, which is why our claim that we have asserted is properly housed with the district court, which is why part of the motion is asking us to be remanded back to the district court so the district court can hear our cause of action for collection on 2 months and 5 days of unpaid room and board from Dr. Penner while he was residing at the Olive Branch.
Why is this not in probate court? These issues sound in probate. We have a guardian. There's a number of issues that really fall under fiduciary responsibility under the guardianship. And probate court has that responsibility, not this court, not district court. And I'm a bit confused why all of this lands on my lap and not downstairs in probate court or in Shiawassie's probate court. And how do we get from Shiawassie's probate court to me?
I'll be happy to address that.
Please.
So in Shiawassie, the Shiawassee probate court was dealing with the capacity of Dr. Penner and whether there should or shouldn't have been a guardian conservator. My client was housing Dr. Penner at that time, which was known to the guardian conservator. And of course, the guardian conservator coordinated with my client to facilitate the move of Dr. Penner because that has to be scheduled and facilitated and there's a process for that. And so there was communication between Olive Branch and Janet Duffy, who was serving at that time, who also does quite a bit of work before the Ingham County Court. But Janet Duffy was an attorney that was serving as the court-appointed guardian conservator. And then Janet Duffy resigned and Kevin King became a temporary guardian conservator. And neither Janet Duffy nor Kevin King really ever took full power over the finances of Dr. Penner. So that's why from the correspondence I have between my client, the Olive Branch, and Janet Duffy, that's why the claim that was known about room and board was not paid at that time.
Okay, let me stop you there. Isn't that malpractice? What the heck happened there? I mean, when I was in practice, I served in that capacity. I was appointed for a number of different things, as I'm sure you are. We take what the judges say and we follow through. We got 2 attorneys who didn't follow through with this, and isn't that something for the state bar as well as probate court?
So what the judge did in probate, well, let me back up for just a second. Let me finish the first thing. So with the Shiawassee probate court, they closed it. They decided to stop the guardian conservatorship, and then they closed the file. So that's why nothing further was done. We actually filed a claim, a statement of claim in the probate court, and it wasn't ever addressed, and there was no accounting done, and the Shiawassee probate court just closed its file.
Okay, well, that's a mistake on their part, unless they don't have jurisdiction because he no longer lives there. Where is the doctor living?
I cannot speak to that.
You all haven't talked?
I don't
Sit
know.
down, counsel. I want to hear from them. Have you all talked?
We have attempted, Your Honor,
Well-
specifically on this issue.
You don't, let me just say, I know I have all very good attorneys in front of me. I was in practice and there were attorneys I hated dealing with, but I talked to them anyways. Don't ever come in front of me without talking to each other, because that's half the battle. The communication resolves a lot. So now I want, from your perspective, where's the doctor living? Why is this in front of me and not probate court, please?
Your Honor, we couldn't agree more on probate court being the exclusive jurisdiction over the issue.
Have you
And
filed there?
not for our claims, Your Honor. They wouldn't have jurisdiction because the determination was Dr. Penner was neither incapacitated or incapable of carrying on his own decision-making.
Okay, where is he living now?
He is living on his own in Holt in a, I'll call it semi-assisted living. He has his own 2-bedroom condominium in Holt. He's drives, He's capable of living on his own. They don't prepare his meals. They don't do any of that for him. He has long since been able to function on his own.
So tell me about this money. Does he owe it or not?
No, Your Honor. And the reason he does not owe it is his daughter attempted to use a power of attorney that was a springing power of attorney that had very specific provisions in it before she could. And she's the one who entered into the contract with the Olive Branch. We're saying she didn't have the authority to do that. And that's just another reason for their claims why they have to be in the probate court.
Okay, so tell me about the daughter. Did the Shiawassee County, from your knowledge, and it might be that plaintiff has to answer this, but did Shiawassee County give her the authority?
No, Your Honor.
She just took it?
She petitioned, she cut him off from his money. He went to legal aid and got a lawyer who then filed the opposing documents. And that's how Janet McDuffie got appointed a temporary guardian over the period of which the process was supposed to happen to determine his capacity. And then they withdrew the guardianship petition after the court hired an expert, Dr. Moss, to opine, and she opined he's perfectly capable of deciding where to live. And he had already contracted with the Marquette, something that Janet McDuffie knew. And Your Honor, Janet McDuffie gave him the authority to move himself. That's the thing that's missing here is Janet McDuffie didn't tell him he could not move to the Marquette. And it's a good thing because the court's expert said her own husband was placed in the Marquette, and that's the perfect setting for Dr. Penner to transition to total independent living.
Janet Duffy is not his daughter.
Correct. Janet McDuffie is the court-appointed
Okay,
temporary guardian.
so how does the daughter takes him to court, finds him incompetent or alleges that, and then the
Correct.
doctor says, but he's not, so Shiawassee closes it. He never signed a document
Correct.
in order to pay, and he was never deemed incompetent,
Correct.
so the daughter signed it?
Correct.
So let's stop right there. Counsel, Ms. Gray, why are you not going after the daughter? She signed the contract.
Your Honor, may I approach?
Just you can talk from there. What's the story with the daughter? Why is she not part of the suit?
Well, she's not part of the suit because at the time at issue, this was all subject to a guardian conservatorship. So what actions that Karen Penner, Dr. Penner's daughter, took prior to the guardian conservatorship is entirely irrelevant.
Wait a minute, did the court give her authority to sign the documents?
The period of time that I'm talking about, there was a guardian conservatorship, and I think I'm going to have to look at this register of action, but I think that actually Karen Penner was a temporary guardian conservator before Ms. Duffy, and then Kevin King was the final guardian conservator. I would have to look at this register of action. I was not part of that. Curtis Zielinski was representing Karen Penner at the time, and I do believe that it all started with her seeking a temporary guardian conservatorship.
But this doctor didn't sign the contract, and are you telling me the court gave some order that somebody had the authority to sign it? If the daughter signed it, she's responsible.
Well, Your Honor, the contracts, again, starting off with the original action that we had filed in district court. So these are form contracts.
I'm well aware, you know, when I was in practice, I represented nursing homes and went and did this collection and the collection actions. And sadly, oftentimes there were relatives who signed the contracts or friends or neighbors and didn't realize they were on the hook. So why is daughter not on the hook? That's the ultimate question. Why is daughter who signed the contract not on the hook?
All of the contracts going back as far as June of 2021 were signed under a durable power of attorney. So she was not signing on her own. She was signing as his agent under a durable power of attorney. According to the contract.
Who gave her the durable power?
Who gave
her the durable power? Was it the doctor or was it the court?
Dr. Penner.
And at some point he revoked that?
I don't know that.
He absolutely revoked it.
When did
And
he
you-
revoke it?
The revocation came, I believe, in October of 2023. But your honor, it's a springing power of attorney, and it's very specific.
As to his competence.
His personal physician had to give a written document, not just,
Does
the
that
olive branch
document,
had doctors that said he was incompetent, but they don't count in order to give the authority under the power of attorney. It had to be his personal physician, who has never opined that he lacked the capacity to do anything.
so why isn't the daughter here? Was that your reading of this? Because if there's nothing where his physician activates that power of attorney, it doesn't exist. She signed the contract on her own.
So, Your Honor, the petition to appoint the guardian began in October 19th of 2023. So I don't know when the revocation, they said the revocation happened in October, whether that revocation was at the same time that the Shiawassee probate court action was started. I don't know the details for that, but let me address something else with the court. Whenever you have a pattern in practice, so there was a contract signed in 2021, there was a contract signed in 2022, there's a contract signed in 2023, and what we're talking about is a short period of time in 2024. Again, there was payment every single month for years, and in our original complaint, we asserted that there was payment made, and they admitted that. They admitted that they paid the room and board every month from the period of time in June of 2021 until the, all the way through January of 2024. No issues in payment. They know that he was residing there. They know he was getting services, and they willingly paid. And then there's this issue of not paying for 2 months, in February of 24, in March of 24, and 5 days in April of 24. So to go back and say, I'm challenging a June 2021 contract based on now claiming that the durable power of attorney was or wasn't in effect. And my point on that is, we're not arguing anything about a 2021 contract. We're arguing all the way forward to 2024 when he was housed there based on the Shiawassee probate court guardian conservator saying he was going to be housed there. At that point, starting in October of 2023, so we're going back to October of 2023, we have a guardian conservatorship in place. The durable power of attorney is now irrelevant. The underlying contract signed by a durable power of attorney, if that needed to be argued in the Shiawassee probate court, I don't know if that did or didn't need to be, but it's not relevant to my client's collection case, because my client's collection case is during a period when Shiawassee has a guardian and conservatorship. So to bring up these issues is not, not relevant at all to what was going on under our court order. We all know that once the Shiawassee probate court orders there will be a guardian for you, you are going to be a protected ward, then my client has to follow that court order. And if whether the ward says I want to go or not, my client, Olive Branch, has to look at the guardian conservator because that's under court order, and my client knows that. So my client
who
can't.
signed in 2023-24? Was it the guardian conservator on behalf of this gentleman or not?
I believe the 20.
I don't want you to believe, I want you to know your case.
Yes, Your Honor. Just a moment. I'll pull the document
Please.
and have it in my hand.
I'll help. It
Thank
was
you.
Karen Penner, the daughter.
So it wasn't even the guardian. So
Correct.
she had no color of authority granted to her under the probate court.
Correct.
And there was
Ever.
no doctor.
Sure.
And it sounds to me like Counsel Duffy and King also knew what was going on and did not intervene, or check with doctors or do anything else either.
Correct, Your Honor. And for point of clarity, Karen Penner petitioned the court to become the guardian. Dr. Penner opposed it. She was never appointed as a temporary guardian, ever. She was asking the court, but Dr. Penner retains the ability. You're only supposed to have a temporary guardian for 30 days because of the actions partially of the plaintiff counter defendant. This case drug out until May of the next year.
What are you asking the court for?
We're asking for a dismissal of the underlying claim because the probate court has 100% jurisdiction over all of the issues that have anything to do with their claim. They had actually made a request in the probate court for payment. There's no question about that. While all of these temporary circumstances were, it needs to be back in front of that judge, and they need to go back to the judge who's already determined that Dr. Penner had the capacity to make his own decisions, and then say, somehow Janet McDuffie did something and then decided she wasn't going to use the funds that were there to pay this bill. Yeah, and I think it's at best a breach of fiduciary duty for her to have left that undone. She's probably going to testify that she gave him the authority to leave and they wouldn't let him leave. Exactly the facts that we've alleged.
Okay, tell me about what you've alleged in terms of specificity, because
Okay.
we all know there has to be specificity, and she's saying there wasn't, and so
Certainly.
tell me about that.
Okay.
And why do I keep your claims alive?
Your Honor, on the conversion claim, there is no question that we have alleged the contract that they're using to have taken his money for this entire period puts them in possession of those funds. What we're also alleging is that Karen Penner had taken approximately 1.4 million of his dollars during this time period, and she was using the process in order that she could retain her control over his accounts and then get away with taking the money. Our allegation is they were lockstep. They wanted him as a private pay client. They provided the doctor's, single doctor, not his private physician, but the doctor's note that she then took. Are they then joint tortfeasors on all of the 1.4 plus the contract money, or is it just the contract money? The facts will bear out how much they're responsible for paying back.
Well, let me ask you this, why is she not in your case? Why is she not brought in? I mean, it appears that the doctor's daughter is committing some fraud here. Why is she not
I
in
will
this
speak
case?
to that plainly,
Please.
Your Honor, and it's in our brief. There's a Ingham County Circuit criminal action that may be turned over to the AG's office. As soon as we sue somebody, they're going to take the fifth and the whole process grinds to a halt. These are joint tort fees.
Right.
We don't have to sue both of them. If she gets joined, that's what's going to happen. The case is going to go nowhere until that's completed.
All right.
She's got Stuart Chambers, her criminal attorney. We have been in contact and he's made it perfectly clear. You sue her and it's not going to go anywhere. So that's why from our perspective, why she's not in.
All right. Anybody want to say anything else? Because I'm ready to roll
Yes, Your Honor, if I may.
briefly.
So I do want to remind the court that the motion before the court, I don't think my co-counsel or my brother in counsel has any motion before the court. The only motion before the court is our motion to strike their counterclaim because their counterclaim fails to state any cause of
Well,
action.
technically, their argument to that is don't do it and they can fix their counterclaim. Wouldn't you agree with that under the court rule? That's my decision.
Yes, correct.
Okay.
But in terms of now they're asking, I guess, in an oral motion that you dismiss the complaint that we filed in district court, I think now over a year ago, 2 years ago now. And that is not before the court. That is not.
Well, I can't do anything about district court. I can only do what's in front of me.
Okay, so Your Honor, there are representations being made here that I know to be inaccurate in terms of a pending criminal investigation. It is my understanding that that has been pursued and that has been, that is not going to happen. That they have tried, Dr. Penner has tried to pursue that, and my understanding is that that is not going to ever occur. That there is no basis for prosecuting Karen Penner criminally. There's a lot of information. This looks complicated, but in my opinion, it is very isolated. My client, the Olive Branch, provided housing for Dr. Penner from June of 2021 until April of 2024. And there's no dispute that it was paid for all the way up until February of 2024. Now, it is true that the probate court, I tried to resolve this in the probate court, Your Honor. And my attempts, I filed a statement of claim. I asked, and the Shiawassee probate court said, this case is closed and we're not going to address that. That's when I filed in district court. I think sometimes I cannot answer for why the Shiawassee probate court would not address this issue. But it was clear in speaking with their court, they knew that there was a statement of claim for the exact amount filed with the probate court and no action was taken. And the case was closed by the court and Kevin was, I can't remember his name right now, and I've said it several times on the record, Kevin King, who's an individual, not an attorney, Your Honor. As an individual, he had already been released by the court. So I think the court's perspective, if I were to assume why the court would not hear that statement of claim, is Kevin King was only appointed for a short period of time. That time ran before the statement of claim was addressed, even though it had been properly presented, even though it was known. I wish the Shiawassee court would have taken care of it, because then my client wouldn't have been chasing this for the past 2 years. How do we get the Shiawassee probate court to address this? I don't know procedurally how we make that happen, because the Shiawassee probate court has closed this and the guardian conservatorship ended. And so they see nothing further to be addressed.
Right.
And that's why an independent action was properly filed in Ingham County, which is the county in which Dr. Pinner was living. And so we filed in Ingham County District Court because of the jurisdictional amount. It was less than $25,000 and he was residing in Ingham County. So that means we have to sue Dr. Pinner in the county in which he resides. It is true, Olive Branch is in Shiawassee County, but you don't have jurisdiction there if you're trying to sue Dr. Pinner. So I think that my motion is properly presented. Karen Pinner is not before this court. Any allegations concerning Karen Pinner are not part of this court action at all, and not part of, they have now set forth their counterclaims in the district court, which the district court didn't allow, and then they filed for superintendent control, which Your Honor did grant, and then they filed their counterclaim. They've had ample opportunity to bring in a necessary party if that's the direction their case was going. Honestly, when they filed the response, this is the first time I've heard of that. So this is when they filed the response to my motion on April 28th, just a few days ago, like last week. That's the first time that I've heard this theory that my client is a joint tortfester with Karen Pinner. That makes no sense. My client is a corporation that provides assisted living under an assisted living license. I just think this is A, not properly pled, and B, not before this court. What's before this court is a 5-count counter complaint, which I have appropriately set forth in my motion, does not state a cause of action. And I am asking this court to dismiss that counterclaim and remand this case back to the district court in Ingham County.
Final word.
Very briefly, Your Honor, I believe that St. Court Rule 2.116 says that if there's a lack of specificity, the remedy is allowing amendment of the claim to add the specificity, not to dismiss the claim. The only way to dismiss the claim is there are no facts possible of being developed that could, and the reason that we have the detail is those are the facts that we will develop and present to the court. If those need to be allegations, they can be made allegations in a complaint. And the only other point is whether or not Bob Davis, who was the main actor here, if he becomes an indispensable party, if his actions independently, either by the entity or by Dr. Penner, we understand that this case would most appropriately be in the Shiawassee County Circuit Court. And we were upfront. We're not trying to hide the fact that we're here because they sued him and then we counterclaim. If the counterclaim, which has to be brought in the probate court, the timeliness of their claim is not an issue and a reason to try to extend jurisdiction where it doesn't exist. If the probate court determines that they didn't make the claim timely, they're the ones who are supposed to determine whether the claim was timely made and determine whether they get paid or not, because the underlying facts, his capacity And her right to use a power of attorney in order to bind him to a contract are exclusively, as we've stated, with as clear a case law as there can be, a determination for the probate court. Your Honor should be frustrated. This should not be here. This isn't the right court for it. If there are any questions, happy to answer.
No, I agree. I'm not the right court for either side. I think Ms. Penner needs to be brought in, and if they're not gonna do a criminal action, oh, well, she's got a good, Attorney Schaefer's a good attorney. She needs to be brought in, I think, by both sides. And I am denying plaintiff's motion for summary disposition. I'm dismissing the complaint without prejudice. This needs to go back to Shiawassee under an appeal or be filed with the probate court here. As to the counterclaim, if you wish it to stay here, and I don't think it's really the appropriate place, you have 30 days to file with specificity and bring in Ms. Penner. Otherwise, please go down to the probate court, and I think it's their jurisdiction to determine the validity of the power of attorney and who in fact should have, could have, would have, did sign that the contract. And without the doctor, I don't know that that power of attorney ever was valid. And the fact that there's a history, yes, I understand in the law we can look at history, but a contract's a contract. And if the wrong person signed it, that person, and I haven't seen all of the fine print of what the nursing home did, but generally it says whoever signs, and it's usually in bold letters, you sign it, you're responsible. So it seems to me Ms. Penner is the one who owes those couple of months. And she was acting without authority, trying to get money from her dad. So if for some reason you all want to redraft this in a format that comports with the jurisdictional amount and types of cases I hear, I'm happy to bring this case back. Otherwise, please go to probate court. This is dismissed without prejudice against both of you. Thank you.
Thank you.
Your Honor, I'll be happy to prepare the order and present it under the 7-day rule if council doesn't agree.
Great.
Okay, thank you.
Thank you.
Thank you for the court's time.
Thank you. Good luck, Doctor.
Thanks.
This is docket 25-6238 CK, the Kronzik firm versus Jessica Thorpe. This is a motion to quash service.
Good morning, Your Honor. Jeffrey Beers, P41693 on behalf of plaintiff.
And we have, all right, on behalf of the defendant.
Yes, Your Honor. Jessica Thorpe representing myself.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth and the penalty of perjury?
I do.
Thank you. Put your hand up. All right, so, ma'am, you are asking the court to quash the service of process?
Yes, Your Honor.
Could you come up to the podium and tell me?
Yes.
I mean, are you saying you didn't get served?
No, Your Honor.
Okay.
Good morning, Your Honor.
Morning.
Jessica Thorpe, appearing on behalf of myself. I am asking the court to quash service and set aside the order for alternate service under Michigan Court Rule 2.105. I understand the court previously granted the order, but based on the record, I respectfully believe the level of due diligence required before moving to alternate service, was not met. Based on the affidavit, the attempts described appear limited and lack sufficient detail to show meaningful efforts at personal service. Additionally, the affidavit indicates that attempts were made and that a notice was left, but I was present at home during those times and did not receive any notice.
Given the layout of my apartment complex and the difficulty in locating my specific unit, I believe these efforts may not reflect completed or reasonably effective attempts at service. Further, there was information available, such as known scheduling and parenting time, that could have made personal service more likely. There is no indication that information was used in making the attempts described, which suggests that reasonable available steps were not fully utilized before seeking alternate service. I want to be clear that I am not trying to avoid this case. I am prepared to respond and participate fully. However, I am asking the court to require that proper service be completed in accordance with the rules.
Well, ma'am, you've availed yourself of the court, so you are fully aware of the complaint now, correct?
Correct.
So can you answer it in 21 or 28 days?
I believe that I could.
Okay, counsel, what happened here?
Your Honor, the defendant was properly served pursuant to court order of alternate service in this case, which was entered by the court on February 6, 2026, pursuant to MCR 2.105. Clearly, the defendant has been served and notified about this suit. Otherwise, how would she know to file this motion to quash service if she had not been served?
All right, what's this case about?
It's for a suit for unpaid legal fees owed to the firm that represented her in a contested divorce.
Okay, and this is properly before me rather than the family court? Was this part of the family court judgment at all in your
No,
retainer?
it's a breach of contract. She's being sued by her own attorney that represented her in the divorce.
Okay. So, ma'am, you want me to quash this? You want to go to start over? You clearly have notice of this. I'm simply going to say, how much time do you need to respond?
I would like the full time, please.
Well, it's generally 21 days with personal service, 28 days through the mail. So I can give you the 28 days just because I can. I shouldn't, but I can. Can you respond in 28 days?
Yes, I can.
Day number 1 starts tomorrow. Consider yourself served.
Thank you, Your Honor.
Thank you, Your Honor. I have a proposed order, if I may
Thank
approach.
you. Ma'am, do you have a copy of the complaint,
Of my complaint?
of their complaint?
I do.
Okay. All right, so ma'am, I've added on here, defendant has 28 days to respond to the complaint filed by plaintiff. So how we count in the law, I know you're not a lawyer, you might want to consult with one. And if you can't afford one, there's legal aid, State Bar of Michigan, you could call them and they can appoint you an attorney for pro bono work. You seem to be very well versed, but there might be some things you want to talk to a lawyer about, but we count tomorrow's day 1, so that's the 6th. And then the weekends are still counted, so it's going to be 28 consecutive days. It has to be filed with the proof of service, file it in this court, with the clerk with the proof of service that you've served them. Okay, and I don't know if you understand all that, but I can't really give you legal advice, but I don't want this to go on and on and on. We need to go forward, and then if you need counsel, please seek counsel so we can cut through all this. All right. The next thing, once they receive your response, we are going to send you all a scheduling order. If the 2 of you can't talk about days, then you'll both come in here and I will set the days. And that's for discovery, exchange of information, and all of that. So that will be the next piece of legal paperwork you'll receive from my chambers. Okay. that you all need to get together and figure out. If you need help doing that, because you don't want to talk, I'm here. But generally, attorneys do this together. But I understand when you're representing yourself and you don't want to talk with them, then you just need to come in here and we'll go in my conference room and we'll work it out. Fair statement, counsel?
Yes, Your Honor.
Any questions, ma'am?
No.
Okay, so we're, just wait one moment. We're gonna get you a copy of all this, okay?
Thank you, Your Honor.
So Brian, give me each 2 copies.
Okay. Being very slow this morning. Oh. If I got them, get 2 each.
Thank you, good luck.
Thank you, Your Honor.
Morning, Your Honor. Andrew Prinz, Assistant Attorney General here on behalf of the Department of Environmental Quality plaintiff.
Thank you.
Teresa Hendricks on behalf of Demolition Contractors, Your Honor.
Thank you. And we have 3 motions. Would we like to start with defendant's motion to accept filing? Or, and then we're gonna have a Smith versus Corey hearing, is that correct?
We're having the motions for attorney fees, but yeah, it probably makes sense to do the motion for leave first.
I guess so. You may proceed.
Your Honor, before our merits hearing, I appreciate the opportunity to
I
address.
can't, if you come up here, I can't hear you, sir.
Thank you. Thank you for the opportunity to address the motion to accept the late filing.
Well, let's cut to the chase. Are you in disagreement? Apparently there was some kind of medical issue. What's the problem here?
Well, Your Honor, I would say we rely on what's in our brief. I think what was demonstrated to us in the filing was I understand that she was dealing with a medical issue of her partner, and I acknowledge that those issues come up and are more important than court deadlines, so.
Great, your motion's granted. I see no reason to belabor this, waste time, waste court reporter time, waste all of your time. I am shocked that good counsel, as you both are, did not simply agree to this. There's been no prejudice shown, and 2 days is 2 days. Come on, let's just move forward.
Thank you, Your Honor.
Granted. All right,
I also move for attorney's fees. If you like, I can go first on my motion for attorney's fees.
well, Sure, but let me just ask you this. Are you both prepared to do a Smith versus Corey hearing? We have experts, we have everything, everyone in place. I don't know who's here in the courtroom.
It hasn't been designated or scheduled as an evidentiary hearing.
Well, I might be a little slow on the uptake here, but when council has a dispute in regard to fees, it's usually a Smith versus Corey hearing where we look at experts and see if there's a reasonableness of the fees, and we use the schedules from the state bar, the experts and all those things. Is that what's at issue here?
We have included all of that, each of us in our fee factors in our briefing, so.
But neither one of you are in agreement, right? So I have to have a hearing and hear that where you do direct cross and follow all those rules, don't I? Or you want me to just do it on the paperwork you both submitted?
Well, the expert opinion that your judge, that the court refers to is of other attorneys and what's reasonable, rather than taking the state bar documents as.
I'm just following the case. I mean, the case globally looks at the state bar and the years of practice. You're all familiar with it. We all in practice every 2 years, we look at it to see if we can raise our fees, right? And so we also use them for the Smith versus Corey hearing. And then it seems that you're both not in agreement with the bill. And so, and the amount being charged. So I think we need to go through an evidentiary hearing. If you're not prepared for that today, we can set it out, or I can hear as much as you want me to, or you can highlight the points that you're in agreement with and then disagreement with. It's your case. I'm here to serve, but I think it probably requires an evidentiary hearing.
I like that approach. There are things I think that we can agree on, such as what the state bar reasonableness is. I don't think we have a disagreement as to our hourly rate. Our disagreement is to how much to allocate to each party. Is that a fair statement?
Well, I think there's a disagreement about how much are the reasonable hours. I mean, I think we have an agreement as far as to what the fee customarily charged in the locality is, but I think the initial disagreement is the number of hours charged.
Which would take an expert in that field to determine. Or you can waive all that and I can determine. But I'm not an expert in environmental anything. I've heard a lot of cases, especially when we had court claims, but that doesn't make me an expert.
So, you know, Judge, I think that the way that we proposed the procedure was that we'd submit our claims. Objections would be filed and then we would have them heard by the court. And I think, you know, what we're seeking is a resubmission because we don't think that there's enough information provided. I think that what's been provided is insufficient to support a claim for attorney fees. So I think we need to go there first, almost.
Okay, well, let me hear from both of you and let's see where we're at. Ma'am, what would you like me to know?
Okay, I just want to correct my thought. This case started with Judge Kennedy and from an inspection in 2014, and then.
Yes, you had just about every judge on our bench, as I recall. Yeah. Sorry about that.
Yes.
Okay, for background, in 2014, there was an inspection of my client's job site. They were at a plant that makes magnesia, and they were going to take down this skinny building that was 6 stories tall called a precipitator. And in that process, there was a day when they weren't working, and the DEQ inspectors came out.
And what inspectors?
DEQ.
Thank you.
And they found fragments around the job site, which were described as in the hundreds to thousands. They made an assumption that this was a job site with regulated asbestos-containing materials rather than just asbestos-containing materials. And from that, they found several violations, and they issued a notice of violations pre-suit. Their lawsuit started in 2018, and it was all built around those regulated asbestos-containing material allegations, and we call that RACM for short.
Okay.
So asbestos containing materials, if it can emit powder, then it's described as friable. And so in the case, the theory that there was RACM on the job site failed. And the court, Judge Kennedy, found there was nothing friable with the asbestos because it emitted no powder using the hand test. So over the course of the 8 years of litigation, the defendant was able to defend itself and prevail in establishing that this type of job site had no RACM involved. And this was important not only to the defendant, who has been in the demolition industry for 60 years, but it would have allowed the state to continue to misinterpret what RACM actually is. And so this was a case that they felt that they had to defend. Once they defeated the RACM allegations in their entirety, there were some leftover violations that were technical in nature. And technical is a word that Judge Kennedy and Judge Jamo used. And then the defendant won the main issue and substantially prevailed. So this court can look at now the statute that governs prevailing fees for the prevailing or substantially prevailing party. So I've cited the subsection of the statute, and it shows that the court may award costs of litigation, including but not limited to reasonable attorney and expert witness fees, to the prevailing party or the substantially prevailing party if the court determines such an award is appropriate. And this statute uses the disjunctive or because there are some cases where there is a main issue and then there are sub-issues that are not the core or the gravamen of the case.
Or the what of the case?
Gravamen. The statute doesn't direct a count-by-count analysis or fee allocation. And under the case law, it's the results that were obtained that matter the most. And winning the main issue is considered prevailing party. And certainly we'll show you in this case how defendant is not only the prevailing party, but the substantially prevailing party. So if you look at case law about winning the main issue, there is a Supreme Court case on it. And it says that basically the prevailing party status turns on who won the main issue and whether that victory material altered the party's legal relationship. In this case, it did both. Defendants won the main RACM issue, and there were 8 out of 10 counts that were RACM dependent. And then that victory barred MDEQ from being able to enforce the liability for the RACM. So it changed the relationship of enforceability, and defendant prevailed on the main issue. So from the record evidence, I have links for this court to summarize where we are at this point. Judge Kennedy, in his 2022 order, found that, we look at the conclusion here. The first paragraph of the conclusion, it says, MDEQ failed to prove that there was any RACM on the worksite premises. So after 8 years of litigation and 10 as we speak here today, we were all 10 years younger when we started this case. I turned 60 this week, so I started this when I was 50 years old.
Happy birthday.
Um, and the other important finding that Judge Kennedy made was that nothing on the job site was friable. And that matters because one of the violations that we were found liable for was a notice violation for how much rackham was estimated to be on the job site. And we'll explain that as we go. But this nothing friable is also in Judge Kennedy's opinion. We also have the complaint, which is attached to our exhibits, and that is that it shows paragraphs 50 through 60, and that 8 of those paragraphs depended on a finding.
Hold on, my thing just screwed up, I'm sorry. We also have the complaint, which is attached to our exhibit, and that is that.
It shows the 10 counts and the 8 of them that are rackham dependent. So if you don't have rackham, then none of those counts apply. So at the end of 2014, when the notice of violations were issued, something really important happened, and that is that one of the violations was for the demo notice, which we refer to as B1, because it's 61.145 B1. And the B1 demo notice is supposed to be sent 10 days before you start demo. In this case, the defendants missed that deadline. And the defendants testified that they found hundreds of these a year, and that jobs get delayed by their customers, and so they have a window where they have to continue to file those. And so this one did get overlooked. In their history, there's no other evidence that they were ever fined for a demo notice for demolition contractors. And so in their response to DEQ, before the suit, 3 years before the lawsuit, they conceded, yes, on B1, we failed to notify. They made a correction and they sent in the notice, and no fines were issued. That wasn't surprising to us because usually notice provisions are a $0 fine. But in 2018, the complaint was filed and it contained the counts 50 through 60. But in none of the counts did it contain the B1 provision specifically. It was never separately pleaded. So we assumed throughout the litigation that that was dropped because we had conceded it pre-suit, and they never saw any fines for it. In 2022, at the merits trial, DEQ re-brought up the B1 demo notice violation at trial. And I argued that it wasn't relevant, it wasn't pled, and I was overruled. And so Judge Kennedy found that there was a violation of B1, and it was based on the pre-suit admission by the defendant. And then in Judge Jamo's opinion, he also cites the B1 violation on his opinion, page 4. But there's no reason to litigate an issue that's conceded. And likewise, there's no reason to ask for attorney's fees for something that was conceded pre-suit.
Okay, let me just stop you there. Let's work this backwards a bit. You're asking for $373,921.48. Do I have that right? Yes. And plaintiff is asking for $16,250.
As Your Honor, we're asking for, in attorney fees, we're asking for $73,792.58.
And what about, explain to me the $16,250, is that included in this or is that in addition to?
The $16,000 is the fines assessed by Judge Jamo.
Was that paid by your company, your client?
No, we plan to appeal those.
Okay, so
So my discussion of the three technical violations go to whether or not it was necessary for them to incur attorney's fees on these three technical violations.
Okay,
So under B1, a concession pre-suit where no fines were issued and it wasn't included in the complaint is inappropriate to award fees for that, because it would inure to their benefit to leave it out of the complaint and then launch it at trial and then ask for fees for it.
so, and bear with me because I wasn't there this decade. So you're telling me they ended up going to trial on something and it was allowed that they never put in the complaint?
Yes,
How did that work? Isn't that a misstep? I mean, if it's not, we're at notice date. If there's no notice, it never should have been heard.
right, there was no amendment, it was not included in any of the trial briefs, and that was one of the basis for our plan to appeal.
And so the judge, whoever it was, allowed it?
Yes, he allowed it because specifically they produced the admission that was made pre-suit. And so he said, well, okay, they're liable for that. Which goes to his decision, but in this decision, were attorney's fees necessary for that? No.
And how much are you asserting for that?
Well, the three technical violations took me 98% of my time was on the Rackham charges, which were the 8 out of the 10 charges. And those are the fees that I've asked for in my brief.
Well, you asked for $357,671.48. Is that correct?
We go to that slide. Yes.
Okay, so I just want to have, math is not my thing. I just want to have a clear picture here. Of the 3,507.61.48, how much of that was due to issues that they never asserted in their complaint? Do you have it broken down like that or not?
The only thing I can give you is 2% for all three of the technical violations.
2% of the 35,000 or 300?
2% of the entire total of 347.
Okay. And
that's for all three technical violations. I put no attorney's fees into the B1 violation because it wasn't pled. I didn't have to answer, didn't have to include it in any of my trial briefs. So that would be 1/3 of the 2%, I guess.
well, the 2% of the 357,000 is $7,153.43. It's 2%. So you're saying to subtract something from that?
So that's for all three technical violations?
Right.
Yes, and so 1/3 of that would be attributable to the B1 violation.
So 1/3 of that, or dividing that into 3, let's say, is $2,384.47. So that leaves that now leaves that 2% less the 2384 at a total of $4,768.96 for those two technicals. Okay. And that is considered in the 357. So would the 357 be less than 2384? Okay. Okay. What else are you claiming?
The next technical violation is regarding the Rackham estimate notice. So that's 61.145 B45. The Judge Kennedy found that that Rackham estimate that Rackham notice needed to be filed with the DEQ, and that was his finding in 2022. This created a confusion for the demolition industry, in particular for my client, because the experts that testified at trial on this said there's no notification required. So my client reached out, one of the staff members reached out to DEQ to find out if notice was required where you have a non-friable asbestos, like the transite siding in good condition, and it remains non-friable throughout the whole job. And the answer they got back from the MDEQ is that notice is not required for non-friable ACM, that
Your Honor.
remains non-friable.
Respectfully, I'd just like to place an objection on the record. Council's trying to introduce evidence that was not presented before the trial courts with respect to liability. This is something that's come after the determination. So we'd object to the court or the submission of this additional new evidence.
Well, let me tell you what I'm interested in, not retrying any of the cases. I'm interested in knowing if the numbers are reasonable. And counsel, you gave me the $357,671.48. We've subtracted out the $2,384.47. So I now have what appears to me to be a request by you of attorney fees, expert fees, costs, all of that, in the amount of $355,287.01.
Okay.
Okay, so I don't need really an explanation from you for that. What I need from them is to tell me, why isn't that reasonable in terms of the hourly wage, the amount of time spent, etc. Right? Because I'm not retrying the issues, and I don't care why Kennedy or JMO ruled. You had substantially most of the case in your favor. They had a few points, and that's where they've come up with the $73,728 or
Okay.
$73,792.58. Plus they're asking for the $16,250 additionally. That was fines, you said?
Yes, Your Honor.
Okay, so I need to know how you're objecting, or did they not charge that? I mean, was the fine, you're appealing that? You didn't pay the fine.
Yeah, so the liability portion where Judge Kennedy found that they were liable for it without it having been pled, that will be determined on appeal, and then if we win, there will be no fines.
Right, and I would quite honestly agree with you. If you were a notice date, you didn't plead it, you don't get it, I'm shocked you listened to it. For whatever reason, because that's why we have the rules in the court rules that would have granted them permission to amend, because as cases go forward, especially as complex as yours, both sides, at least how I read it and how I do it, I give you both sides to amend and provide notice and follow the court rules so we can actually get to the bottom line. Doesn't appear that happened here. I don't know what the Court of Appeals will do. They surprise me every day. But I honestly agree with your position on that. But I haven't read 10 years of transcripts, which is why several months ago, I sent it back to Judge JMO to finish. The costs, he sent it to me. That's really kind of math and reasonableness. So what about the $73,792.58 that they are claiming in fees?
Those are being claimed for the 3 technical violations, and then where I left off in discussing DEQ, saying the opposite of what Judge Kennedy said, is it goes to whether or not they improved their position for litigation, and it appears that they did not. So it's not relevant until we get to this point. This is the first time we've had a court be able to review the fees under the specific statute.
So you're saying the 3 areas, those are the 3, that's the 2% that you're talking about?
Yeah, out of the 2%, there's 3 technical violations, the one that was not pled,
Yes.
and then the estimate notice, which the court found was required, and the DEQ subsequently said it's not required. And I used that to show that they haven't improved their position through litigation, and the confusion now is worse because they litigated it, and we have a court saying something opposite their own experts. They have a department you can email if you're a contractor and say, how does this work? And so we have the actual answer from them.
So I'm sorry to interrupt you, ma'am, but sir, are you, the 73,000, do those go to the issues that were the technical violations, one of which she has said, she's actually said 2/3 is not good, one is, third is okay?
Yes, Your Honor, the 73,000 is related to the 3 claims DEQ prevailed on, and I'm happy and prepared to argue why we're entitled to those fees.
Okay, sir, let me understand something though. Those issues, were they originally pled in your complaint?
Yes, all the issues, the notice, we claim that notice was not timely filed. And these issues,
What do you mean notice? I'm talking about in the complaint. Did you originally plead these? Was it properly in front of JMO and or Kennedy?
yes, these issues were properly pled before the court. We pled that the defendant failed to provide timely notice of the
Notice
demolition.
of what?
And so they were subject to fines because of it.
Wait a minute, no, they failed to provide notice of what?
Of the demolition. So basically, the way the statute works is before anybody can demolish a building, they've got to provide notice to the regulatory agency, which is DEQ. And that's how the enforcement works. So
That's how the what works?
enforcement.
Thank
So DEQ's got to go out and enforce the statute, and they do that by inspecting the activities. So if they don't have the notice, they can't inspect activities.
Okay. And ma'am, you're saying that was not pled in the original complaint?
That's correct, I'll show your honor.
Okay, well, here's part of my confusion. I guess I can retry this. I mean, from the perspective of looking at all of this through that window. But why aren't you just taking all of these issues as to what was triable and what was not to the Court of Appeals and then bringing it back to me for a Smith versus Corey hearing?
We tried an interim appeal, and the Court of Appeals says it was not considered a final order, either at the Kennedy stage or the JMO stage.
Because the attorney fees were still outstanding?
Yes, well, at the time that I tried the interim appeal, it was before the damages phase.
Okay.
And after the liability phase.
Okay, so bear with me here. I'm thinking out loud, but I can make whatever decision I make, and we can spend a lot of time. But if the Court of Appeals sees it your way, we're going to be recalculating, and if they see it his way, we're going to be recalculating. So your issues are really closed except for attorney fees, the Smith versus Corey hearing. And the Court of Appeals doesn't need the Smith versus Corey hearing. It has to determine if those were triable events or not, because that's when the Smith versus Corey hearing is right for me. Otherwise, we're doing this twice. So doesn't it make sense to go to the Court of Appeals now and then come back to me upon their remand to determine cost based on what they conclude was triable and not triable?
If we succeed on the appeals issues, then the hearing today will stand and we will have another delay in the case.
Okay. think we're gonna end up in a hearing no matter what. I don't know what the Court of Appeals is gonna do, but I think this is premature because he's saying they were absolutely triable and you didn't follow the rules. You're saying you did and they were not triable and you had to expend attorney fees. So I don't know where the Court of Appeals is gonna come in on this. And I'm happy to, as soon as they make a ruling, get to a Smith versus Corey. I think we're wasting time.
I think we're going to be saving time because if you say a hearing will be needed either way, we will save on determining what fees are appropriate and reasonable. And we have the opportunity to not have to come back.
Well,
So for example, I don't know if it's not really an evidentiary issue, but if you look on screen in the complaint, there is no count under B1 in the entire, and the complaint counts start at 50. So you can easily just scan them here on the very bottom of the page. The first count is under B3I. The second one is under B4-6. And you can just scan these. None of them are B1.
okay, then let me get to the other Smith versus Corey issue. Are you both in agreement that the hourly rates that you both charged, that the experts charged, that all of the billables were absolutely correct, not inflated or conflated?
I think I thought we agreed on that.
The hourly rates, Your Honor,
The hourly rates you're in agreement with?
we're in agreement with the hourly rate.
What about the hours expended on each item?
We are not in agreement with the defendant's hours.
Based on your response, it wasn't an issue of the number of hours spent, it was the attorney's fees sought for those. So for example, I expended a certain number of hours and 182 of them were on the second trial. His argument was that the second trial is not entitled to have fees. We bifurcated the case.
Okay. So
That was the only argument I'm aware of. I didn't see any argument in his brief that my entries by line item were excessive.
are you claiming that her entries are excessive?
We are claiming what she's claiming for the reasonable number of hours are excessive.
Did you specifically plead that? I mean, here's the Smith versus Corey. You both read it, you know it, okay? I have to look at, were the fees that were charged reasonable? And you're both saying, yep, all of that's reasonable. Then I have to look at, were any hours double dipped? Was something that an expert would have done in 5 hours done in 25 hours? I mean, was all of that reasonable? Are you saying that she wasn't reasonable in her expenditure of time and billing?
So the issue is, I understand Smith versus Corey, you figure the rate customarily charged and then the reasonable hours.
Yes.
So the issue here is that Judge Jamo entered an order awarding the defendant attorney fees for the claims they prevailed on and plaintiff attorney fees for the claims that they prevailed on. The Michigan Court of Appeals has said when you have cases where you have multiple claims, that litigants can only claim if they're entitled to attorney fees for specific claims they prevailed on. They can only claim fees related to work related to those claims.
Correct.
And that goes into the reasonable number of hours, and that's what our issue is. We assert that the defendant has not identified with respect to her hours. I think she claims a number of hours, but she doesn't indicate that those hours are related to the work related to the 6 claims they prevailed on. We went through each and every item task so basically we created a chart and we identified each task we're claiming attorney fees for. And we identified how they were related to the claims we prevailed on. And to the extent a brief or a deposition had work unrelated to the claims we prevailed on and related to the claims that they prevailed on, we reduced our number of hours by a percentage basis. So we accounted for the fact that not all that work was related to the fees, to the claims we prevailed on. They didn't do that. The defendants didn't do this. They just They claim all the items that they worked on, all the tasks that they did, and then they apply this blanket percentage. 98% was related to the claims they prevailed on, they say. And they
And you're
apply it to
disputing
every
that.
single task.
Right, and you're disputing that.
We dispute it. We say that there needs to be more detail, there needs to be more
She
substantiation.
provide detail, you just disagree with the detail she's provided and as to how they relate to each one of the claims they prevailed on.
Yes, we disagree with the detail. We don't think it's sufficient.
And there you have it. That's the crux of what we need to do the math. So this is not as simple as 357,000 less this or that. This is going through your detailed billing, have you testify, have an expert testify, and then I come up with an amount.
Okay, here's the crux.
Yes.
Their block billing, they had to go back and estimate how much they spent on those 3 technical violations as well. So they give generalities as well, because
Yes.
the statute doesn't provide allocation by count. It doesn't even talk about that. And if it's not in there, the legislature didn't intend it to be. So we look at the Supreme Court rule, which says who won the main issue.
Yes, but then
Okay.
once we get there, there has to be a reasonableness in terms of hours. This isn't my first Smith versus Corey hearing. And we have to go through the billing and they have to tell me whether it's reasonable or not and why. You tell me why it's reasonable and we go through and we do the math.
We have both billing statements and nobody broke it down by how many minutes per day was
Then how would
involved
you like me to decide, ma'am? You
based
want me
on.
to just give you what you want and they're saying it's not, it's the bill's essentially not related.
The same way that the court, the Michigan Supreme Court did is what is the main issue? If, for example, 80% of the complaint and 80% of the litigation and all of my time except for about 2% of de minimis hours went to the Rackham claims, you can determine what's reasonable. I will live with court's indulgence. And the same can be said for Mr. Prince. He kept no track of the individual time he spent on each particular count. And so he's gone back and estimated, well, on this line item, I think I spent 33% on these technical claims. And on this one, I think I spent 66%. And on this line item, but there's no contemporaneous record because the statute doesn't even talk about keeping track and billing clients per count.
Your Honor, I completely concur with what you're saying, that I completely concur with what you're saying, that the issue is the reasonable hours claim. We don't have agreement on what the reasonable hours.
And she doesn't have an agreement on yours because you can't just estimate. That's not what we as lawyers do. It's a 0.3, a 0.6, or whatever, for whatever you did. Did you do that or are you just estimating your hours?
I went through each document. So like if we did a brief, I reviewed the brief and considered how much was related to, how much of the work was related to claims we prevailed on and how much was related to claims we didn't. And then I adjusted the hours correspondingly. Same thing with depositions. I reviewed the depositions, how many pages were related to claims we prevailed on, how many weren't, and that's how I adjusted it. So I went through each task we've claimed. I've reviewed that document or transcript or brief and identified how much was related to what we prevailed on, how much wasn't. So I think we've done far more than defendant has. Defendants just tried to blanket a 98% of fees for claims they prevailed on and only 2% for claims we prevailed on. I
Well,
think
her position is even if you prevailed on them, they shouldn't have been heard because they were not pled.
right. And I understand that, but that's for the Court of Appeals.
That's why I'm saying maybe we send it to the Court of Appeals. Otherwise, what I do is I take the 300, let's see. This is a real easy solution. And then the Court of Appeals can just yell at me. Your position, ma'am, is that they did not plead, and so none of those issues should have been heard, but how does that, tell me the 1% they prevailed on, or the 2%, there was a third, so where does that, how does that fit in? Just clarify that in my head.
Sure. All right, my slide here, there's 3 technical provisions.
Yes.
That they prevailed on. One was the first one we discussed, which was not pled.
Okay,
All right, moving on to the ones that were pled.
they only, did they,
They pled the other 2.
yes, prevailed on one and not the other,
They prevailed on 2.
on 2, okay, that's where the 2 come in, so would it be, okay, so then my math is not correct, so the one, so it would be the 357, 671, 48 minus the $4,000 basically that they prevailed on, so it would only be that one claim that they did not plead and did not.
Okay,
They did not plead in
They
one.
did not prevail on, so that, or they did not plead, so that shouldn't have been there. There's really only one issue they didn't,
there were, the
there were
judges,
3,
3, one was not pled, so no fees.
so that's the $2,384.
Correct.
Yeah,
The second one was the Rackham notice for the estimate. They prevailed on that and they pled that.
okay,
All right. They did not improve their position and they did not get the results obtained that they wanted because the DEQ is still saying that notice is not required for non-friable. So there's contradiction in enforcement caused by their litigation. We now have no clarity and the litigation on that count was meaningless. It certainly was not the main issue and certainly couldn't be construed as a prevailing party because they didn't prevail on that matter.
So
They
there's
certainly
no-
had a finding of a violation, but they did not prevail.
okay,
So that's the B41, the Rackham estimate notice.
so
So that,
that's the $7,153, which is the 2%. Only the 2,384 would be subtracted, not the 4,000. Is that correct?
oh, we have to go through the third one.
Okay.
So I
Who
said,
prevails?
my
I don't care
calculation,
about that. Who prevailed? Did they plead it and who prevailed?
they prevailed and they pleaded the generator label provision.
Okay,
And I argue that they're not the prevailing party, even though they had a finding that there was a violation. And the record evidence that I use for that is Judge Jamo's statement, which came out under cross-exam of the defendant. Judge Jamo found that when they were asking for $197,000 in fees or fines at the damages hearing, that the DEQ likely confused the generator label requirement for a different one. And his words were, as defendant's counsel pointed out, however, these considerations are irrelevant to the violations currently before the court. The generator label defendant has been found liable for failing to properly affix.
Okay, the generator labeled the defendant. Is that what you said? Okay.
Has been found liable for failing to properly affix, does not include information about what material is contained in a waste container or whether the material is Rackham. The generator label is only required to state the location where the waste was generated and who the generator can be identified as. And then below that, Judge Jamo says, counsel's questioning and the testimony elicited from Meade O'Brien, who is here today on behalf of the DEQ, indicated that DEQ's recommendation for those fines was more likely than not affected by some confusion regarding the label violation defendant was actually found liable for. And the court considers this apparent confusion as a mitigating factor in defendant's favor. So in sum, on our appeal, we will be able to argue that the entire prosecution, the DEQ, was confusing the generator label requirement with an asbestos warning label. Judge Jamo, rather than delay it for an appeal before he decided, because we had already tried an interim or interlocutory appeal, he said, well, what I'm going to do is I'm going to mitigate that fine to $250 because of this confusion, because he could see by the testimony that they didn't know which generator label was. So that was the way he dealt with it. And that's the same way that this court can deal with it when looking at the fees. You can mitigate the request of fees based on their confusion and based on the drastic reduction in what they were requesting for fines to $250.
Okay,
And there's a third violation, and our position is that they're not entitled to fees for that. Oh, this is the third violation, sorry.
okay.
Yeah.
Okay, sir?
Thank you, Your Honor. I would say, what we've discussed, a lot of what we've discussed this morning is just trying to relitigate what has already been litigated before. Judge Kennedy issued an opinion finding demolition contractors had 3 violations of the statute. These same issues were brought again at the penalty portion of the proceedings before Judge Jamo, and he declined to go back into them. He felt that they were for the Court of Appeals. The defendants filed a motion for reconsideration of Judge Jamo's order. And again, he issued an order declining to revisit the liability determinations, because those are properly should be brought before the Court of Appeals. And we'd submit the same. To the extent defendant wants to argue those liability violations, they have every right to, but the appropriate place is to do it in the Court of Appeals. The issue here is the attorney fees, and Judge Jamo directed that they be done per Smith versus Corey. And we have to take into account the fact that Judge Jamo said that the defendant is entitled to fees for the claims they prevailed on, 6, and that plaintiff DEQ is entitled to attorney fees for the claims that they prevailed on, 3. And that basically goes in compliance with the court rules. If you have cases that have multiple claims, that litigants are entitled to fees if they prevailed on those claims for the claims they prevailed on. So that's how we have this sort of this determination we have to make with respect to reasonable number of hours, because we have to look at Smith versus Corey. And so basically you've got the fee customarily charged in the locality. There's no argument about that. The argument that we have is with respect to the reasonable number of hours claimed. So with respect to how the defendant tried to parse, the 6 versus 3, was they said 98% of the work that they did was related to the claims that they prevailed on, and only 2% was related to the claims that DEQ prevailed on. And DEQ objects to that. We don't think it's reasonable. We think it's way overinflated. I think, we'll just take, so they claim $373,000 in attorney fees and costs. So $357,000 of that is attorney fees. So it was put into, they have sort of 2 different requests, because this proceeding was bifurcated. There was the liability portion, and then there was the penalty portion. So of that $357,000, they claim $115,000 in relation to the penalty portion. Now, the penalty portion of the proceeding was related to assessing fines for the violations of the statute. So they're claiming $115,000 in attorney fees in relation to work defending the court's assessment of fines for violations of that they were found liable of. Had nothing to do with the claims they prevailed on. There shouldn't have been hardly any attorney fees for that portion of the proceeding that they've claimed, because it had nothing to do with the claims they prevailed on. It had everything to do with the claims that DEQ prevailed on. So with respect to that portion, you know, the blanket statement just doesn't provide sufficient evidence that those fees were related to the claims they prevailed on. And that's required, and it's in the brief, the Court of Appeals decision that says, you know, you've got to substantiate it. And if you don't substantiate it, then the other party's entitled to an evidentiary hearing. And it's our position that it hasn't been substantiated at this point sufficiently. Same thing with the $241,000 in attorney fees in relation to the liability portion. Again, you know, I think that defendant asserts that only 2% was related to the technical violations. I would submit that a lot more time than just 2% was spent on the technical violations. We spent pages of transcript going back and forth on the notice violations. We spent a substantial amount of time arguing whether this was a demolition or a renovation. There was a lot of work that that went into those technical violations, and 2% is not reasonable. Again, so when you have the entries that the defendant made, they're just sort of general entries like work on a brief, motion, that sort of thing. There's no attempt to identify how those were related to the claims they prevailed on. So we'd say that with respect to attorney fees, that hasn't been met. The burden hasn't been met to show how those fees were related to the claims they prevailed on. So we say they aren't at this point entitled to attorney fees. With respect to, they also asked for interest. The Court of Appeals has ruled that with respect to costs and attorney fees, that parties are not entitled to interest. Then we go down to costs, and they claim $16,000 in costs. Again, same sort of general entries. And again, we claim that they failed to identify how these costs were related to the claims they prevailed on. They've also claimed of that 16,000, they've 7,000 of that, they claimed in expert witness fees. And they have not demonstrated that those $7,000 were for compensable time. We admit expert fees are compensable if it's related to time in the court, preparation for court time, but they're not entitled to strategy, compensation for strategy meetings, doing work reviewing opposing parties' claims, advising counsel. And again, we just have general entries, meeting with JF. And then some of the entries say, reading email from JR advising about exhibits for opening. And John Rakoff was one of their experts. That indicates to me that that work was related to strategizing and not necessarily compensable. Wasn't related to in-court time or prepping for in-court time. So again, when it comes to what they're requesting, they fail to demonstrate they're entitled to it at this point because there's not enough description. Deposition expenses, they asked of that 16,000, they asked for 3,000 in deposition expenses. Now you can get deposition expenses if the deposition is filed with the court and then used at trial for purposes other than impeachment, and that's statutory. MCL 600.2549, part of the RJA. Defendant has not demonstrated that any of those transcripts that they're claiming time for met those criteria. Therefore, they're not entitled to be reimbursed for those costs. Lastly, they claim $335 in mileage costs for co-counsel Ben O'Hearn. And the court has
Court of Appeals has ruled that travel expenses of attorneys are not taxable. Also, they request interest, and as we've said before, those are not recoverable. Interest is not recoverable as ruled by the Court of Appeals. A lot of time was spent on talking about the success versus failure of the cases. A lot of that's accounted for with respect to how the fees are divvied up. We're only being given our fees for the claims we prevailed on. So with respect to the relative success of the case, we were successful on those claims, and we shouldn't be punished for the fact we were successful on them. The fact that we didn't prevail on the other claims is accounted for because we're not given attorney fees for those claims. Defendant is given attorney fees for those claims. So with respect to the relative success of the case, it's already accounted for in how things are supposed to be divvied up.
Did you say it was 335 miles or dollars for the miles?
$335 for the mileage.
Thank you.
So we would say that, you know, in one of the cases, the Purview case cited by defendants, they indicated that the most important Smith factor that, you know, comes after you get to your base rate is the success of the case. Purdue doesn't say that. Even though they say that in brief, it doesn't say that. In fact, the Purdue court vacated the trial court's judgment because the trial court primarily focused on the success of the case and didn't consider the other factors that you're required to under Smith. So I think the main objection we have here is a lack of, you know, of all the costs that are claimed. There's a lack of evidence to show that the costs claimed are related to the 6 claims they prevailed on. I think there's definitely a overlap into claims that the department prevailed on. And there needs to be that substantiation in order for them to be entitled to their attorney fees and costs. We're not saying that they're not entitled to them. We're just saying that what they provided so far is not sufficient. And so what we're asking is for either they be asked to do a new submittal or that we get an evidentiary hearing where we just go through it like you indicated.
What is your $73,792.58 based on?
So that's based on, it's in my affidavit.
But in response to what counsel said here today.
So it's related to the 3 claims we prevailed on. So there was a violation for lack of notice, lack of an estimate, lack of generator labels. So I went through the file and each and every item that we filed, whether it was a brief, whether it was a deposition, whether it was a motion, and reviewed those documents to identify what portion was related to the claims we prevailed on and what portion wasn't. And so if, you know, a brief, you know, if we had 1 hour for a brief and 40% of that was related to stuff that was unrelated to claims we prevailed on, I reduced the number of hours charged for that task by that percentage. So then the reasonable number of hours under the Smith versus Curry is decreased. So we're getting a more accurate determination of the reasonable number of hours expended on the claim because we're reducing that portion of the hours that were related to the defendant's claims. So I did that with each and every item that we claimed expenses on, made those reductions, and they differ for each task. It's not just a blanket. So those were related for the work we did. And that gave us the base rate, which was approximately $87,000. So then, based on the fact that, you know, a notice violation may be less technical to prove, we reduced that $10,000 based on the factors you're required to apply under Smith versus Curry. Basically, the complexity of the case. We would say that some of the technical violations were not as complex, and we concede that, and we reduced our rate, our request by $10,000. You know, I would say that with respect to our request, a lot of statements have been made about how they're just technical violations. There was a lot that went into it. There were arguments about whether a subcontractor was liable. So we had to deal with that. There were arguments about what type of activity was occurring, whether it was a demolition or it was an abatement. So we had to deal with that. There's a lot of foundational issues that we had to deal with in order to substantiate the violations we prevailed on. So it's just calling them technical does a disservice to the amount of work that went involved to proving them. You know, and to the extent, you know, we would claim that failing to file a notice is an important violation. You know, the way the statute works is that DEQ is the regulatory agency. They implement their regulations by inspecting work sites. So if you have the regulated community not informing the inspectors of work, the system fails because there's no inspections. So that is an important violation in our opinion. Obviously, you know, we did not prevail on the majority, but this was an issue that had been argued about for years, about whether transite was a regulated material. And it was a difficult case. We did not prevail on that issue, but it wasn't a frivolous case. And just because we didn't prevail on the majority of the claims doesn't mean that we're not entitled to our fees. So we'd submit that we're entitled to, I think the total was $73,792.58. And, you know, when we talk about the ratio 6 versus 3, the main issue that the defendants prevailed on was it was a regulated material. So once that was determined, 5 of those violations fell away. So it wasn't, I wouldn't quantify 6 versus 3 as being that much more work, because once that Rackham determination was issued, 5 of them fell away. It was just simple technical, factual determinations like, was the material wetted? Was it
Material what?
wetted? Wet. Was it lowered to the ground carefully? Was it containerized? Simple factual questions. So the main issue was there a certain amount of Rackham? And then there were a number of smaller issues. So again, I guess in sum, I would just say this. We object to the defendant's claims because we don't feel there's sufficient evidence at this point to show that what they're claiming, specifically for the reasonable number of hours and for the cost, that certain tasks are related to the 6 claims they prevailed on. We're not saying that they're not ultimately entitled to their fees. They are, just like we're entitled to our fees. We think that there needs to be more evidence. So we're asking either that they redo their submittal or that we have an evidentiary hearing, like you're suggesting, Smith versus Curry, because we don't have sufficient evidence to support what they're asking for. We feel that the department, DEQ, has gone through the whole file and done the best job we can with respect to reducing the reasonable number of hours for each task we're requesting reimbursement for, based on how much that was related to defendant's work versus plaintiff's work. And we think that we've made a significant effort to comply with what the court requires. Thank you.
Thank you. Counsel, can you address the penalty portion? Is that part of the 300,000+ you're requesting?
The penalty portion, you mean where the fines are reduced from 170?
He's asserting, I believe, if I understood it correctly, that there's a liability portion and there's a penalty portion, and that I think, did you mean to say, sir, that the 115,000 are part of the 350 some thousand she's claiming?
Yes, that,
Is that in fact correct?
Yes, I'm claiming attorney's fees for the evidentiary hearing that we bifurcated. And we were also the prevailing party of that proceeding as well, because they were asking for 197,000 in fees, and they got, and we prevailed to the 90%. 90, over 90%.
Okay, and they have a request for the 73,792.58. Technically, under your theory, that would also be divided by 3, and they're the only one on the one issue, not, I'm sorry, on the 2 issues, not the 1.
Correct, and that the statute nor the Supreme Court case allows for the non-prevailing party or the least prevailing party to get any fees. So if you look at the screen here, I just pulled up the statute again to be sure that we're reading the same language, and it shows that the court may award costs of litigation, including but not limited to, so there is no limitation, reasonable attorney's fees and expert witness fees to the prevailing or substantially prevailing party. And in this case, defendant is both the prevailing and the substantially prevailing party. There is no statute or case law that says that the substantially losing party is entitled to fees.
I think it's really not fees, it'd be an offset for the time they spent on the issues they prevailed on, and you're saying they don't get that.
Correct. The other thing I wanted to draw the court's attention to, just to get the case on the record, the Michigan Supreme Court case that I cited, which says that whoever won the main issue is considered the prevailing party, is Ronish Construction Group, Inc. versus Lofts on the 9 LLC 499 Mich 544 886 Northwest 2nd 113 2006.
2006.
Sorry, 16. Thanks for catching that. The other thing that I wanted to bring to the court's attention is that the defendant knew and the experts knew that this was a highly technical area and that the state didn't know what Rackham was from day one. That's what they answered. And they put the defendants through 8 years of litigation. Up until today, we're at 10 years. They didn't understand their own generator label, which Judge Jamo expressly called out. And their own DEQ is giving advice to contractors now that is contrary to the finding that they got under Judge Jamo. And when they went to the evidentiary hearing and asked for $197,000 in fines, this is what Judge Jamo considered. There was an identical list of fines for the identical alleged violations to the owner of the facility. They settled all 10 of the allegations for $5,000. Judge Jamo pointed out that for the 3 technical violations alone, DEQ was now asking $197,000, $192,000 more than somebody else paid for the exact same fines. And he agreed with us that this was the DEQ trying to penalize the defendant for defending the case and prevailing on the issue of Rackham. And on page 15 of his order, he actually says it here. He says, "It is therefore difficult to discern a different interpretation of Meade O'Brien's testimony other than what it says on its face. Because defendant pursued litigation and because defendant prevailed at litigation, the MDEQ has recalculated the recommended fines to an amount $192,000 higher than a company charged with the same exact violations, who accepted liability on all 10 violations and settled with the department. However, the court recognizes that this is not a dispositive consideration, but is merely one factor for the court to consider alongside the factors listed in the statute regarding fees." So in this court, it's the first time that we have an opportunity to show how punitive, vengeful, and malicious this prosecution was from the beginning. And to require us to come back again after requesting an interlocutory appeal and not having a decision on this statute and on the determination at least of who was the prevailing party or substantially prevailing party, leaves the defendant again at a severe disadvantage, subject to more fines. And having an evidentiary hearing would be no better than to sit there and go through every single entry on Mr. Prince's itemization and say, how did you come up with 33% on this? For every single item over the 10 years. And the same with me. The best we can do is look at the material that we produced, what's in the trial briefs, what's in the expert testimony, and give our best estimate or sworn statement based on what the file reflects. You could put Mr. Prince through a deposition, and he won't be able to come up with anything more specific than he has right now. And the same is true for both of us, because none of us were tracking things by count.
Okay. So I've heard enough. So my note to the Court of Appeals, so we'll be reading this, is I'm happy to take this back to reconsider the order that I'm giving you now under a true Smith versus Corey hearing rather than counsel testifying. Smith versus Corey requires more than what has happened today. It's a true evidentiary hearing. I've heard many of them, and it certainly is more intense and in detail than today. However, based on what I've heard today and read, here's the decision and here's the calculations. And you don't have to like it, you're going to the Court of Appeals anyway, but this is going to give you some finality to go to the Court of Appeals with, and then when they jettison it back to me, if they disagree, again, happy to set aside a day or two to do all the picky things that haven't been done today that should be done under Smith versus Corey, which I think is very clear. And we'll have some testimony and go line by line if necessary. So the defense is requesting $357,671.48, which, I'm sorry, the defendant is requesting that, and that's based on what they've prevailed. Hope I have the number right. The plaintiff prevailed on, and they've claimed the 2%, or defense has agreed to 2%, which was the $7,153.43, which I divided by 3, and plaintiff prevailed on 2 of the 3 issues. One was not pled properly, and I agree that should not have been before the other judges. So I subtracted $4,768.96, leaving a total of $352,902.52. Now, there's an issue of fines in the amount of $16,250, which the plaintiff claims defense owes. I don't know if they do or not. I leave that in the capable hands of the Court of Appeals, but I have subtracted it out in all fairness. Therefore, it's the finding of this court that the plaintiff owes defendant the total of $336,652.52. That's the final order. Argue it all the way up to the Court of Appeals, Supreme Court, bring it back to me, and I'm happy to have the hearing as I've suggested. This was the date and time for a Smith versus Corey evidentiary hearing. I understood there were 3 motions, and that's what we were doing. We didn't do it. So based on what you've all told me, there's my math. Please send it to the Court of Appeals, and I'll see you back in a couple of years.
With respect to DEQ's request for attorney fees,
You're not the prevailing party. I've given you a little bit of credit. They're paying the fines. Take it up with the Court of Appeals. Anything else?
Oh, Your Honor.
Great.
if I just say, how much was subtracted? I think it's the 373,921.
Was it 373? I used the 357,671.48. Counsel, I think that was the number that I found. I don't, maybe I've got the math. I can redo the math. Is it 371
Total number for me?
for you?
Yes, 347,569.73.
Huh? Wait a minute, I have you requesting $357,671.48. Is that incorrect?
Let's see if my slide is wrong.
Well, for all I know, there's so many numbers and this is so large, maybe I plucked the wrong number out. I could certainly redo the math. I know how I calculated the bottom line.
So my slide that I'm showing, I'm not showing.
What's your total request?
347, 5,
47?
yes,
Okay,
569.73.
okay, then I stand corrected. Give me a moment. Okay. Okay. The requested number is $347,569.73. Times that by 2% is 6,951.39. Dividing that by 3, that means I subtract $2,317.13. Timesing that by 2, that is $4,634.26, which I subtract from the $347,569.73, leaving a total of $342,935.47. Minus the fines of $16,250, that leaves plaintiff owing defendant $326,685.47. That's the final order. It closes this case. It's ready for the Court of Appeals. Who's preparing the order?
I can prepare it.
Great. Anything further?
No, Your Honor.
I look forward to seeing you again with a full-blown hearing. If you have any question of what that means, Should we need to go there, please meet with me. Let's get our ducks in a row and then let's have that meaningful hearing. Thank you. That is all for the record.
Thank you, Your Honor.
Thank you.